let's do this. I need to take a quick bathroom break. So let me take a bathroom break. That'll give Ken time, and then I'm happy to address the Madden matter. It looks like both of you are here from Provo. So let's do that next. We'll be in recess for a moment. Ready on the Madden matter?
Your Honor, we are ready on the Caleb Johnson matter.
Hang on though, I think we were going to do the Madden matter next, so that, because we have these guys from Utah County. So let me handle that matter, and then we'll go from there. And then, just so everyone in the audience is aware, we do have a number of matters that are remaining on the calendar. These are the matters that I show. I have David Anderson, Rex Bohall, Tyrone Daniels. We did that, didn't we? No, Daniels. Anderson, okay. Cameron Dutchin, Caleb Johnson, Tamale Kamai, Nicole Osler, Robert Torres, Tyler Williams, and Gomez Hernandez. If I didn't call your name and you believe that you're on my calendar, raise your hand and my bailiff will get you where you need to be. All right, this is State of Utah versus Elijah Madden. 3 matters today set for competency hearing: 1300, 1301, and 1302. Counsel, if you'll state your appearances for the record.
Wayne Vandegraff, Utah County Attorney's Office.
Thank you.
We have Jeremy Shimada. Jeremy Shimada, you're dismissed. You're not.
Hang on, Mr. Madden. Mr. Madden.
You be dismissed, sir.
Mr. Madden.
We are the living flesh and blood man,
All right,
Your Honor.
so if you'll state your appearance again.
Jeremy Shimada from Utah County. And why is he stating his presence?
Mr. Madden, he is counsel of record. We just...
Counsel for me.
All right. I need you to listen to the court for a moment.
Are you saying that he's my counsel? Is that what you're saying?
He is your counsel.
He is
right
not
now.
my counsel. I have never hired him. I have put multiple reports in, notice of self-representation. Jeremy Shimada does not represent me, nor is it allowable for you to appoint
All right.
representation.
So I'm going to stop you for a minute, Mr. Madden, because we can get to that in just a minute. We have to address...
Sir, you're dismissed.
He's not dismissed.
Yes, he is dismissed. He's
This is
not
my
counsel.
courtroom, Mr. Madden, and I'll
I
determine
have a
when...
Fourth Amendment right.
All right. I'm going to stop you for a moment. This is my courtroom. I'll determine when your attorney is dismissed.
He is not my attorney,
He
Your
is
Honor.
currently your
No,
attorney.
he's not.
Stop. We are here on a competency evaluation. Mr. Madden was determined incompetent, was sent for restoration,
No.
and I now have a competency report that indicates that he was restored to competency. Are there any objections to the latest report?
No objection from the state, Your Honor.
Judge, there is not an objection from the defense if the court is going to allow Mr. Madden to proceed pro se at this time.
Sui juris.
I believe that under a competency finding, he has a constitutional right to do that. However, if the court is not going to allow him to proceed pro se, then I would make some objections that I would put on the record. So it just depends on the route the court is taking.
And I am inclined to go through the Framptacoloqui and determine how to proceed. So my understanding, Mr. Madden, is that you do not want to be represented by counsel. Is that correct? That's a yes or no? That's a yes or no? Mr. Madden,
We have the right to talk.
Mr.
We have
Madden.
never been represented by pro se, nor have we ever been pro se. Are you
Right.
able to say sui juris for the record, Your Honor? Are you able to say that?
Mr. Madden, this is a yes or no question. Do you want to represent yourself?
Your Honor, are you going to continue to
Yes
cause
or
treason?
no?
How
Mr.
about the writ
Madden?
of habeas corpus that's been
Mr.
filed?
Madden, do you want to represent yourself?
I am representing myself. I have been this whole time, 9 months. You've had me illegally
you
incarcerated for
haven't
9
been-
months with
okay.
no probable cause. And
Do you
no
want to
injured
listen
party.
to me, or do you want to go back in the holding cell until you're going to listen? Are you going to listen? Do you want to represent yourself? Yes.
I'm representing myself.
Do you want to represent yourself? Yes or no? Yes or no?
I am representing myself.
So I'm going to take that as you would like to represent yourself. You have established that and asked for that many times, but because I could never get through the Framptacoloqui with you, I've not been able to make the requisite findings for you to represent yourself. So we have dealt with the issue of competency. He has been found competent. There are no objections to the competency. Yes, counsel.
You want me to prepare that order, Your Honor?
Yes, let's have you prepare that order. Thank you. I'll adopt the findings. Everyone's adopting the findings. If you'll prepare the order for my signature, I'm going to have you stay for just a little bit so that we can see if we can get through the Framptacoloqui or not. With regard to the Framptacoloqui, which I am required by law to go through with you, I must advise you first that anything you say on the record can and will be used against you. Do you understand that?
Do you understand that you're
I'm asking
in charge
you a
of treason
question.
and judicial misconduct?
Mr. Madden?
Do you understand that there is no injured party? Do you understand that you committed improper venue transfer and that this is the 5th court that has tried to hold proceedings over me with no injured
I
party?
didn't transfer anything,
Do you know
Mr.
that
Madden?
I have a 6th Amendment right
All right.
to face my accuser?
And
Where is
here
my
we-
accuser?
And here we are again, unable to get through the Framptacoloqui because
Because you
won't
refuse
answer
to honor
a
your oath of
question.
office. What is your oath of office and bond number on the record and for the record?
Okay. I'm going to give you one final chance to answer my questions. If you can't answer them, I'm taking you back in the holding cell, and we'll have to set this over where you will be willing to answer the questions at some point in time. I cannot have you represent yourself unless I make certain findings.
You don't have the
If
right
I
to make those
can't,
findings.
well, all right. If that's how you want to play the game, then there's no reason to have a further hearing on this matter, and I'll keep counsel on the
Counsel
case.
is fired. Counsel does not represent me, nor has he ever. Your intention to perpetrate that is fraud. Fraud in contract.
And Mr. Madden, I'm going to have you hold for just a minute. Do you want to set a preliminary hearing so we can actually make some progress on this case, given the fact that he's unwilling to go through
Chelsea
the
Koch has
Framptacoloqui?
proceeded without sufficient
Mr.
evidence
Madden?
in direct violation
Mr. Madden?
of subsection 7717-3. Denied
If
habeas
you do
corpus
not
protections
stop,
contrary to
Mr. Madden, you're going to be
subsections
taken in-
77-30-10
Go ahead.
and 77-30-11.
Mr. Madden.
Engaged in conduct prejudicial to the
We'll be in
administration of
recess
justice,
until-
to the office into disrepute in violation of subsection let go of me 77A-11-105, failed to receive and investigate lawful complaints
Dad, come on, take
contrary
it,
to
Dad.
78. Stop it! Let go of, Your Honor, you're really gonna let this happen? Oh my gosh, guys, this is ridiculous. Chill the fuck out. We're not slamming this guy on the wall. Chill the fuck out. I'm left.
Another one?
Well, it might be actual administrative based on that's a factor that you consider that.
So I haven't done one of those before. Okay. So FAA, that was a great job. Great job. No, I did. Oh yeah, he was good at it. You know what he's doing now? I have no idea. Traveling the world to the brand. Airbnb. Wow.
You guys want these?
No.
I did see him for yes, I mean the 4 year period. He has all applications. This is just for. So he hasn't asked for it. It just disappears. Essentially told him, yeah, praise. Yeah, go and catch up.
He's a prosecutor. You think he has friends?
That makes a point. I don't know if yes, we did something that's strategy, and that's all you're doing. That's true. I mean, all is in your people. I have that. But it's not a case scenario. It's not a terrible case. My wife won't play, but I don't play. She's a very beautiful. I go to her with the half market invitation. Right? Well, so you said the 20th, or you landed on the 20th. Yeah. So, right. I mean, I know. What's the app? It's just different. It's just the people change. You're not going to be your best friend. Let's go because it's just like, all this was like, it's almost does he sell or does he rent it? Well, he's over, yeah, I know, yeah. That's how you got a conversation that up, right? Yeah, he's going to show the world. Or he's not going to show. That's just some control. I mean, I haven't done it ever. Sure, it's probably that's true. Right, no, for you, it's not right. That's something we can consider. I don't know. So, I did not, right? I have 2 hours. I got to go play golf. Yeah.
What do you have ever done? Address over Utah County State Sheriff's. It's optional.
case. Please remain seated. The third district court is now back in session.
All right. Due to the safety concerns, I'm not going to have Mr. Madden out in the audience again. Counsel, I guess the concern I have is these are charges that if we were able to proceed, he probably wouldn't even have served this much time in custody, I assume, at this point. And so is there anything we can do to move them along? I know you're in an unusual position and a precarious position. I know the state doesn't have a dog in the fight in this part of it, but what do you suggest, counsel?
Judge, the issue that I have is that if we were to set this for a preliminary hearing, I would not be able to put forth any sort of a defense based on an inability to have any sort of communication.
Understood.
So at this point, Judge, my ask is that we hold an evidentiary hearing on the competency evaluation that was submitted. At this point, it would be on the state to prove that he is competent to stand trial after he has been found not competent. And I think that simply going through that route, I know it's not the greatest of answer, but if we do end up getting to a not competent at that point, the case would remain open pending a civil commitment potentially, or if there is no civil commitment being sought, then the case could still just remain open under the statute. So as it is for me, Judge, I can't go forward with the preliminary hearing just where the posture is, where I have no communication. So at this point, this would be the next best option that I have.
And so your position is based on your inability to communicate and the behavior that has been ongoing, that you believe that he has not yet been restored to competency.
I believe that there is zero ability for him to assist in his defense with counsel representing him, and quite frankly, for him to appear pro se at this point as well. So yes, that would be my position. And so that's why I would either be asking for a finding of not competent and sent back for more time at the state hospital, or if we need to hold that evidentiary hearing for the state to prove that he is competent.
Counsel, how would you like to proceed with regard to this issue?
Your Honor, Mr. Madden has been in custody for 269 days now. Even if he had pled guilty as charged with his criminal history, he would have received jail as a condition to probation. He would have been released from custody several months ago.
I know, and that's the irony, right?
I'm very concerned about him remaining in custody. I differ slightly in Mr. Shimada's opinion. I don't think his unwillingness, I see it as unwillingness to cooperate with Mr. Shimada rather than a competency issue. Mr. Shimada is very capable. Mr. Shimada works with the Veterans Court. And in spite of the fact that this case has been transferred to the 3rd District, Mr. Madden's prior defense counsel was working on a Veterans Court resolution for his earlier cases. Mr. Shimada indicated that that option is still a possibility, even though it's in the 4th District. If Mr. Madden is willing to cooperate, I can't predict how quickly he would be released from custody, but there are means for him to be released. I think it is a willful choice not to cooperate with Mr. Shimada, not a competency issue. I'm willing to set a competency hearing and discuss that and explore it. I don't know what else to do.
And I think that's our only option under the statute once it has been challenged. We're in an unusual procedural posture because of our inability to get through a colloquy with regard to Frampton, with our inability to get through even a court hearing, with your inability to be prepared, and I understand your position and what position you're being put in because of his unwillingness to cooperate and to help with his defense. And I struggle with how long he's been in custody. Like all of us are right here now. I can't release him yet because we can't have a conversation even about that. And so I think our next step is to have an evidentiary hearing given the challenge to the competency, and let's have the report indicated that there are 2 different doctors, one who did the restoration, one who did the competency. I'll leave it to you two to determine who you want to have here. I guess my preference is to figure out like, when we can do that. If we can do that by WebEx, sometimes that makes it easier for the doctors. If they're willing to be by WebEx at least, and if there's a stipulation with regard to that, which I'm fine with, I'll defer to both of you. The problem that we have with all of this too is my calendar is such that it's going to take some time, and if we have Mr. Madden here as well on this, which he has the right to be, I'm not sure we'll get through it. So,
just for your Honor's information, the first evaluator was never able to speak with Mr. Madden because he declined. So I would call the second evaluator. Mr. Madden cooperated and visited with him, so he's the one I would call to testify. And if there is no objection to a WebEx hearing, I would offer that as a possibility. I would ask for a special set.
Yeah. And I think WebEx, I would prefer counsel be here in person,
Understood.
but let's have the doctors by WebEx, and we'll have Mr. Madden here in person. You guys have been here my entire calendar. You've heard kind of some of the dates that I've been throwing around. I don't know if any of those work for you. The earliest date I have is November 7th at 2 o'clock.
That would work for defense, Judge.
I'm available at that time, Your Honor.
Let's set it for December 7th at 2 o'clock. I will pencil that in on my calendar so that I don't set anything else. I realize that we're coming upon a time of year where we're going to have a hard time getting people to appear in court. So I'll ask that you guys consult with the doctors that you intend to have here. And then if that date doesn't work, we'll figure out another date.
Okay.
And let's do it as quickly as possible so that more dates don't fill up and push us out farther.
Understood.
Thank you, Judge.
Anything else we need to address on the record today?
Not at this point.
Thank you both. I appreciate your being here and I appreciate your patience.
Thank you.
All right, Mr. Crandall, you said that you had a matter that was set for preliminary hearing. Is that correct?
That's correct, Your Honor. I did want to just call the Nicole Osler matter just so we can get her out of here, though.